Hello students, good morning everyone. So in this lecture, I again introduce myself Guneet Kaur, and in this lecture, we'll be talking about Limited Liability Partnership Act 2008, and we'll be discussing the important topics presented by me. So let's start. What are the important topics? First of all, what is the meaning of an LLP, limited liability? So LLP means an incorporated partnership formed and registered under the Act. So LLP means an incorporated partnership formed and registered under this Act. So LLP is basically a combination of both a company and a partnership. So LLP is also known as a hybrid organization because it contains the feature of a corporate structure as well as partnership firm structure. So I hope it is clear. Limited liability partnership. So it is in partnership. It has features of a company. It is a hybrid organization registered under the LLP Act 2008. So moving ahead, what are the features of LLP? So let's understand what are the features of an LLP. First of all, it's a body corporate. So an LLP is a body corporate under the LLP Act 2008. A LLP is formed by the registration of an incorporation document with the registrar of companies. Students, I'm stressing upon a point, incorporation document. So it means that an LLP to be registered, to be formed, it's very important to have an incorporation document. This document is the conclusive evidence that LLP is formed. LLP is a body corporate. It has a separate legal identity which is formed under the LLP Act 2008. Next important feature of LLP is separate legal entity. So, a LLP is a legal entity separate from its partners. It can hold property such as movable, immovable, shares, securities, etc. in its own name. Like a company, limited liability partnership is also a separate legal entity. It can hold its property. You can have a property on the name of your company, such as movable, immovable, shares, securities in its own name. Third important feature is perpetual succession. So perpetual succession means if there is any death, if there is any insanity, if there is any retirement or insolvency. So these important terms, insanity, retirement, insolvency, and death. These factors, these reasons does not affect the existence of an LLP. For example, students, a partnership. We know that partnership is a mutual agreement between the partners. If any of the partners retire or if any of the partnership enters, in that case, or if any of the partners is considered insolvent, in that case, the entire partnership comes to an end and a new partnership agreement begins. But in LLP, there is a perpetual succession. No matter if any of the member dies, no matter if any of the partners retires, or no matter if any of the members becomes insolvent, the LLP shall continue like company. So like I said, LLP is a combination of two things, a company and partnership. It has features of both these things. Moving ahead. Next feature is no mutual agency. There is no mutual agency in case of LLP, thus no partner would be liable on account of the independent or unauthorized action of other partners. It means that there is no mutual agency. No mutual agency means that no partner will be liable for the independent or unauthorized actions of other partners. For example, in partnership, there is mutual agency. If there are any decisions taken by one partner, all the partners have to agree upon that. All partners are equally liable. Whereas in limited liability partnership, there is no mutual agency. No one member will be liable for the actions of other member for the misconduct. Agreed? So next important features is limited liability. As the name says, limited liability. The liability of the partners in LLP will be limited to their agreed contribution, to their agreed contribution in the LLP. So it's a very important thing because the name of the act is limited liability. How much limited it is depends upon their contribution. If a partner is coming into a partnership, say for 50%, then his liability will be equivalent to the 50% to their agreed contribution. Next important feature is minimum and maximum number of partners. So every LLP shall have at least 2 partners and shall have also at least 2 individuals as designated partners. So students, I'm stressing upon these highlighted points because it's important. Minimum 2 partners in an LLP is required. 2 partners plus additional 2 designated partners, of whom at least one shall be resident in India. So for an LLP, you need 2 person as your 2 partners plus additional 2 members as designated partners. Out of those designated partners, 1 person should be resident in India. And for the maximum number of partners, there is no maximum limit on the partners in LLP. So the act is silent. You can have as many partners in your LLP. So moving ahead, LLP versus partnership firm. So what are the difference between an LLP versus partnership firm? So we know that LLP is a hybrid organization, as I've already told you, but there are certain distinctions. What are these distinctions? We'll look upon it now. Partnership firm. So the Indian Partnership Act 1932 is the regulating act for the partnership firm, whereas the LLP, Limited Liability Partnership Act 2008, governs the limited liability partnership. Next basis is body corporate. So partnership firm, it is not a body corporate. Partnership firm is the totality of its partners, whereas LLP is a body corporate. So we already know that partnership is just an agreement between its partners. It does not have a separate legal identity. It is not an artificial legal person, whereas LLP, it is a body corporate. Next basis is separate legal entity. Partnership firm, it has no distinct legal entity different from its members, whereas LLP, it is a legal entity separate from its members. It enjoys a different legal entity. You can have any number of properties registered in its own name in LLP. Next is perpetual succession. Like we have already discussed in the features of an LLP, that the death, insanity, retirement, or insolvency of the partners may affect its existence. It has no perpetual succession. We know that the partnership firms comes to an end. We know that partnership comes to an end with the death, insanity, retirement of the partners. So it has no perpetual succession, whereas in LLP, the death, insanity, retirement does not affect the existence. The company continues, members may come and go, but LLP stays here or stays in existence. So the next basis is name. So no guidelines. The partners can have any name as per their choice. So for the name of a partnership firm, there are no specific guidelines. The partners can have any name as per their choice, whereas in LLP, name of the LLP must contain a word or a suffix as LLP. For example, Ernst & Young LLP. So the name, the LLP must be there in the name of the company. Next important basis is liability. In partnership firm, liability of each partner is unlimited. It can be extended up to the personal assets. So see the word unlimited. In partnership, liability of each partner is unlimited. They can go to the personal assets of the partners. Whereas in LLP, liability of each partner is limited to the extent of the agreed contribution, except in case of willful fraud. So I hope it's understand the major difference in partnership is they have unlimited liability, whereas in LLP, the liability of each partner is limited. So designated partners, there is no provision for such partners in the Partnership Act 1932. So there is no provision for the designated partners in the partnership firm. Whereas we know that in LLP, at least 2 designated partners are required. At least 2 partners are required, 2 designated partners are required in the limited liability partnership. So next important basis is annual filing of documents. In partnership firm, the partnership firm is not required to file any annual document with the registrar of firms, whereas LLP is required to file annual statements of accounts, statement of solvency, annual return with the LLP every year. So LLP is required to file the annual statement of accounts, statement of solvency, annual return with the registrar every year. So let's move ahead to the next topic, which is LLP versus LLC. Limited liability partnership versus limited liability company. So this is an important question we often get in exams. What is the difference between an LLP versus partnership, LLP versus LLC? So in limited liability company, the regulating act is the Companies Act 2013, whereas in the limited liability partnership, we know that the regulating act is the LLP Act 2008. Next basis is members or the partners. So in LLP, limited liability company, the person who invests the money in the shares are known as members of the company, whereas in LLP, the person who contribute to LLP are known as partners of the LLP. So let's understand what are the number of members should be there in LLC versus LLP. So in limited liability company, in a private company, minimum members are 2, maximum 50, whereas in public company, minimum 7 members, maximum there is no such limit. But in LLP, we know that there must be 2 minimum partners, maximum there is no such limit. The act is silent on the maximum number of members that an LLP must have. The LLP must have 2 partners minimum and 2 designated partners. So this is the main thing that we must remember for the LLP, that 2 minimum members and 2 designated members are required. Moving ahead, the next basis is name. In limited liability company, name of the public company must contain the word limited and private company to contain the word private limited as suffix. So if an LLC is formed, if it's a private one, it must contain the word private limited. If it's a public company, it must contain the word limited company. I hope it's clear, because this is the basic of distinction. If you're reading a company name, how will you identify that whether it's a partnership, whether it's an LLP, whether it's an LLC? So these suffixes are the terms that make your company distinctive and different from the other companies. Whereas in LLP, the name of the LLP should contain the word limited liability partnership or simple LLP as suffix. Next important basis is liability of members. So in limited liability company, the liability of a member is limited to the amount unpaid on the shares held by them. For example, if I am holding 50% shares in a company and I have paid only for 30%, so the remaining 20% is still the unpaid amount on the shares held by the person. So this is the liability. He is liable for the unpaid amount on the shares held by them. Whereas in limited liability partnership, we know that liability of each partner is limited to the extent of his agreed contribution except in case of willful fraud. I hope that is clear. Next important basis is minimum number of directors or designated partners. So in limited liability company, a private company must have at least 2 directors minimum, and a public company must have at least 3 directors. Whereas in limited liability partnership, minimum 2 designated partners are required. Next important basis is audit of accounts. So in a company, in a limited liability company, audit of accounts is mandatory, whereas in limited liability partnership, audit of accounts is required if the annual turnover of a company exceeds 60 lakh. So this limit was earlier 40 lakh, but now it has been increased to 60 lakh rupees, or if the contribution exceeds 25 lakh. So a company and LLP is required to get its accounts audited if the annual turnover exceeds 60 lakhs or the contribution exceeds 25 lakhs. So this is the main distinction between an LLC and an LLP. Moving ahead, so this is a very important process of incorporation of a new LLP. So how an LLP is formed? What is its process? So I can tell you that it's a 5-step process, as we can see it on the board, that there are 5 steps, 5 square boxes. Step 1 says deciding the partners and designated partners. We'll be discussing in the next slides in detail about these steps. So just have a read, we can have a look at it. What are the steps in the process of incorporation of a new LLP? Step 1 says deciding the partners and designated partners. Step 2 says obtaining DPIN and digital signature certificate. Step 3, checking the availability of name. Step 4, drafting of LLP agreement. Step 5, electronic filing of some documents with ROC. So let's see in detail what are these steps, what are their meaning, when they are required, and what all things are important in these steps. So step 1, stepwise procedure for the incorporation of new LLP. Step 1 is deciding the partners and designated partners. So it's very important. We know by this slide we know that at least 2 minimum partners are required in an LLP plus 2 designated partners. So LLP can be incorporated with a minimum of 2 partners, who should be individuals or body corporate through their nominees. Apart from the partners, 2 designated partners are also required, who can be individuals and at least one of them shall be resident in India. A person or nominees of a body corporate intending to be appointed as designated partner of LLP should hold a DPIN, designated partner identification number, allotted by the Ministry of Corporate Affairs, MCA. So step 1 of the process of incorporation of new LLP. If you have to form a new limited liability partnership company, the first step says that you have to decide who will be your minimum partners, who will be your partners, and you want at least 2 minimum partners. Additionally, apart from these 2 partners, you need 2 designated partners. The question arises, who are these designated partners? So designated partners are those who hold a DPIN, known as designated partner identification number. So basically this DPIN, it's an 8-digit number allotted by the central government to the partners to whom you assign that this person will be my designated partner. Then he has to file an application with the central government, and then they allot him a 8-digit number known as DPIN. Okay, moving ahead, step 2. Step 2 is, like we have talked about, obtaining DPIN and digital signature certificate. So once you have decided your minimum partners and designated partners, the next step is obtain the DPIN and digital signature certificate. So DPIN, what is a DPIN? It is an 8-digit number allotted by the central government in order to identify a particular person. It can be obtained by making online application in e-form 7. in E-Form 7 to central government and submitting the physical application along with the necessary identity address proof and prescribed fee. So what is a DPIN? Basically, you have to file an application to the central government in E-Form 7. So that's an important form, E-Form 7. And next is what is digital signature certificate. So once the partners have obtained their DPIN, partners of the proposed LLP must get their signature to be fixed on the e-forms, is required to obtain class 2 or class 3 digital signature certificate from the certifying authority. So these two things are very important, students. First, they have to obtain their DPIN, and next is DSC, digital signature certificate. Moving ahead, step 3, checking the availability of name. So students, once you have decided your partners, your designated partners, you have obtained the DPIN, you have obtained the digital signature certificate from the certifying authority. The next step is checking the availability of name. Basis the business you are doing, basis the nature of the work that LLP is going to do, they proposed a name for their company. Then they have to at least give 6 names, and out of these 6 names, the government chooses which one, the registrar of the companies chooses which one is available. The next step is to select the name of the proposed LLP, because selection of name is crucial for the image of the enterprise. I hope it is clear, because the name is your brand mark or brand image of your company. So it's very important that the name of your company matches with the work that the company is doing. So for this also, the application is made in E-Form 1 of Rule 18 subsection 5 of the LLP for the reservation of the desired name. So you have to again file an application for the name in E-Form number 1. Moving ahead, step 4, drafting of LLP agreement. So once all the above 3 steps are done, you have completed all the applications, you have submitted everything. Next step is drafting an LLP agreement. We often get question, what is an LLP agreement? What are the contents of an LLP agreement? So LLP agreement means any written agreement between the partners of the LLP or between the limited liability partnership and its partners, which determine the mutual rights and duties of the partners and their rights and duties in relation to that limited liability partnership. So basically, LLP agreement is basically an agreement between the partners where they mutually decide their duties, what will be their profit sharing ratio. It will contain the name of the LLP, the proposed business, remuneration, and everything. All the details will be mentioned in this LLP agreement. Moving ahead, step 5, electronic filing of some documents. The next step is filing of the following documents electronically through the medium of e-forms prescribed with the registrar of LLP for incorporation of the LLP on payment of prescribed fees. So once you have completed all the previous steps, step 5 says that you are required to file some documents, E-Form 1, E-Form 2, E-Form 3, E-Form 4 and 7. So all these forms, all these applications are required to be submitted with the registrar of LLP. A proof of address of the registered office should also be required to be filed with the registrar of the companies. Step 6, and this is the final step, which is issue of certificate of incorporation by ROC, section 12. After the registrar is satisfied that all the formalities with respect to incorporation, all the above conditions have been fulfilled, all the above application for the name, DPIN, DSC, everything has been done. If the registrar is satisfied, then he will register the documents and issue a certificate of incorporation in Form 16 within a period of 14 days from the date of filing of Form 2. So this is the conclusive evidence. Like I told you, the certificate of incorporation is the conclusive evidence that the limited liability partnership is incorporated by the name specified therein, LLPIN, ROC assigns a limited liability partnership identification number LLP in for every LLP which is registered. So once your company is registered, the ROC, Registrar of the Companies, will issue a limited liability partnership identification number. This identification number is the conclusive evidence that the LLP is formed. I hope these steps are clear because these steps include all the process of incorporation of a new LLP. Thank you all.